I think it will go a long way toward bringing our country together, which our country needs. And they worked long, they worked hard, and frankly, they worked very quickly on something that will be spoken about 100 years from now and 200 years from now. Extremely important. Essentially, you cannot take somebody out of a race because an opponent would like to have it that way. And it has nothing to do with the fact that it's the leading candidate, whether it was the leading candidate or a candidate that was well down on the totem pole. You cannot take somebody out of a race. The voters can take the person out of the race very quickly, but a court shouldn't be doing that, and the Supreme Court saw that very well. And I really do believe, I think it will go a long way toward bringing our country together.
Things are going to start happening to me now.
You've done all the reading. You're a scholar, you're a professor. You've done all the reading. You've done the intellectual heavy lifting.
More or less, eat shit and die.
You wouldn't know a fact if it begged you all night long.
Want to give the wrong impression, because I am very high.
Ran up behind him with a hatchet. Smash, smash, smash.
Yeah. Care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
Welcome, everybody, to the Libertarian Podcast Review. We're blowing out with some Tim Pool. In case I'm going to look at the chat. Minder, it's live. Oh, look at that. Is this live? It is. Welcome, everybody. This is Tyler Yonke, special SCOTUS edition of the Libertarian Podcast Review. Let me just give you, by the way, so I've read the whole 20 pages ruling, and we'll get to that. Trump had started off with him making a little comment there. Someone also mentioned that the one and only Keith Olbermann chimed in, and we are going to go to that. Let's see if I can find it here. Keith Olbermann writes, the Supreme Court has betrayed democracy. Its members, including Jackson, Kagan, and Sotomayor, have proved themselves inept at reading comprehension. Well, they're women. And collectively, the court, in quotes, has shown itself to be corrupt and illegitimate. It must be dissolved. Always. These guys. By the way, get to it ASAP. I need sleep. Okay, we'll get to it. So I'm on the West Coast. It's 8:30. My wife went to visit our daughter in San Diego. So I'm game. I'm going to be here for a while. So I'll get to it when I get to it. I already did a cycling podcast. And I know you guys are like, say what? Where do we find this? You'll find it out there. It's called Between Two Wheels. I'm the Zach Galifianakis of cycling. So just letting you know that. So let me see here. Do I have, I need to go to the slides because I need to bring up my coffee, right? We need to do some coffee stuff here. Now it's taking me forever. I didn't have this ready to go. foxandsons.com for all your, let's see if this is the one. For all your coffee needs, go to foxandsons.com, get 18% off of orders of $25 or more. This is not the updated one, but that's the one you need. Oh, there it is, 18%. There you go. So yeah, I had a great coffee today, and as always, so there you go. That's what you need. All right. I'm excited about this. Let me give you a heads up. I went down, had an interview with Adam Nutter. Check that out. I really enjoyed it myself. Then I talked to Josh Smith. I really enjoyed that one myself. Man, am I conflicted. I felt like I needed to do some sort of disclaimer at the front and, about Adrian, because I'm friends, and I'm going to talk to him. He DM'd me, or I DM'd him, and he commented, yeah, talk to me. So I felt, and as I'm doing the disclaimer, and even as I'm doing the interview, I'm like, I agree with both of them, and then I disagree with both of them, and maybe my disclaimers are just coming across as being really shitty. So maybe I need to just shut up and let them do the talking, them do the fighting. I'm enjoying it. I mean, so I'm like arguing against one at one point, and as I'm doing it, even I'm like, yeah, but I actually now I agree. So I don't know what the fuck. It's like two friends fighting, and honestly, I don't know that I care enough. I don't want to have them have a kumbaya moment. I'm enjoying all this. Okay, it's 11:30 here, dude. I'm tired. I have two kids under 4. Wow, way to go. Yeah, so welcome everybody. Okay, so let's get to it then. We'll get right to it. By the way, before I do that, I'm going to play one other thing that I saw here. I thought this was let's play this real quick. This douche, Dr. Hansen, I guess.
The judge in Lewis County, Judge McLeod has said that he will decide March 15th on my disqualification lawsuit against Thomas Massey. I'll share more on that later.
Okay, I have no idea what it's about. What are you going to disqualify him for? And that's the big question. So we had SCOTUS coming up here, Keith Olbermeyer, all these guys, Olbermann, all these people making big issues. SCOTUS comes up here with a ruling today. I talked about this earlier when they had their arguments, and I said at the time, I think this is going to be 8190 ruling for Trump. At the time, listening to the arguments, Tyler is the LP Jerry Springer. Oh man, I never wrote a check to a hooker on my business account like Jerry Springer did. No thanks. But yes, your sentiment is there. Maybe the Phil Donahue, the good first one. So comes in, there's a lawsuit, as you guys know. I don't know if I need to rehash that whole thing, but I told you at the time, listening to the oral arguments, felt really strong that it was going to go Trump's way. Comes out 9-0. Now, there's an unsigned opinion. We'll get to that. And then, and maybe for minder's sake, I'll give you the overview, and then I will break into all of it a little bit more. So they come out 9-0 opinion. That's strong. So when Keith Olbermann is like, they don't have reading comprehension, I'm like, at 9-0, it's a little tough when you have a unanimous court. Now it's split decision, not split decision, split opinions. Unsigned opinion, but then Amy Coney Barrett has her own opinion. She concurs with the ruling, disagrees with a little bit of thing, and then wants to take some opinions about some strife that's going on. And then the 3 other chicks on the court have a concurring opinion with the ruling, but they object to one facet of it. And I don't know which way I go with this necessarily on all of it, but the point is, here's the breakdown. State courts can't nullify or remove someone for insurrection and remove them off the federal ballot. State courts don't have that power that they say. Perfectly fine. We'll get to it. There's a lot of they didn't break into whether there was an insurrection. They didn't need to. One, and by the way, that was probably best for them not to. And this is kind of the aspect that you get. Wait, I'm getting distracted here. JC says, if you're going to do a Fannie Willis episode, Brad Bakley would be a good guest to have on. Are you saying I'm not capable of doing it all myself? Maybe I will have him on. You said he watched it. I've watched a lot of that as well myself, so I'm pretty well up on it, and it would be actually good to. He's down in Georgia, so I know that. So maybe I'll contact him and try to do. I didn't follow him on Twitter, so if you have any suggestions on how to get a hold of him, that'd be great. Okay, so there was a lot of issues at stake. One, the determination, and you think of like what they do in law, elements. So you got to do this element, 4 different factors, and they all have to be present for this to work. And then therefore there's liability or what have you. One was insurrection. Was there an insurrection that took place? If so, then he's guilty of an insurrection. Then it goes down there. They went to the end and said, do you even have this ability? It's like you see this a lot of times in court cases, standing. Do you even have the ability to bring a case before this court? Okay. If not, we're not even going to take the issue up. We're not going to say, oh, would have been this. And if you did have standing, here's would have been the outcome. They're like, no. We're not going to waste our time. And they didn't waste their time with whether there was an insurrection or not. Now, the 3 hags that had a concurring ruling opinion, but differed on the enforcement aspect, they kept talking about insurrectionists, da-da-da-da-da. So that's kind of thing. So the main idea is states can't nullify or remove someone or have any enforcement mechanism for removing someone from federal ballot. They could do do so for a state ballot, not federal. Okay, then the main opinion is, and here's how it's going to be done. And they give a breakdown. Amy Coney Barrett says, whoa, I agree with the ruling. The state courts can't do it. You don't need to go any further and say how that gets done. And by the way, let's be nice. That's really what she says. And then Jackson, Sotomayor, and Kagan, they come in and they go, well, state courts, yes, we agree. State courts don't have this ability to do so. Granted, it's all good, and we'll walk through that. So Minder has this, so he can go to bed here. How are you motherfuckers doing? Okay, thanks, Jimmy. So anyway, then the three of them come out and say, yes, state courts can do that, but with the reading of Dobbs, you don't need to then go anything further than what the issue is before the court, which is, can they do this? You don't need to then go forward and tell them how it could be done. Now you've narrowed the playing field as far as how this is. And so and we'll walk through this. So deep breath. I'm drinking, what am I drinking here? I'm drinking a Hen House. It's literally has this is what happens when you send your wife out to buy beer. She comes back with chickens on your beer. But look at that. I'm fine with it. All right, let's first look at this, and I'm going to look at the actual ruling here. But here it is. There's Trump feeling all happy with his extra long tie. I don't know, is tie supposed to go that far down below your belt buckle? It used to. I think that's too far. I think that's too long for a belt to be going down. Jimmy Finger said, "I'm glad I came in here. I need people to be around, and you guys seem awesome already." That's true. Not wrong there. Okay, so we'll just give this breakdown. Supreme Court ruled the states cannot disqualify former President Donald, didn't say J. Trump, but it's Donald J. Trump from the ballot for his role in January 6th. Let's go back to the Keith Olbermann thing. This is what you are, and this is why I caution you against people like Barnes, very, very intelligent attorney, but he's too partisan on some issues. And when you're too partisan on some issues, you tend to say bullshit that gets your legions in a, like basically he said, okay, Barnes has said, Robert Barnes has said, Trump can't be indicted for any crimes since he once held president. You can't do them even when he's out of office. I don't believe that's true, and I don't think the Supreme Court's going to end up ruling that way, but there's going to be a lot of people that are going to be upset because they're expecting, your expectations are going to be this. You got the Keith Olbermann types. His expectations are the MSNBC thing, which is, yes, he's an insurrectionist. No, he's not an insurrectionist. His actions and that stuff that day, I'm sorry, you could dislike or whatever. That was not a form of insurrection. So calm down. And when you get 9-0 pushing back, look, if they thought he had been more involved as an insurrectionist, they might have found a way that then you can say the states can do this. And once you find the way that the states can do this, then you can apply it there. And now you've got Trump, and then you've got a problem. But I think the aspect was, no. One, we're never going to find that this happened. Okay. And then two, the states just don't have the applicability to do so. So that's the problem with the Olbermann situation as well, which is, okay, let's say he's a full-on insurrectionist. Did the states have the power to do so? Well, the reading comprehension says so. Well, anyway, they don't. All 9 justices agreed that Colorado cannot remove Trump from the ballot. But 4 justices, Justice Amy Coney Barrett, get a real name, in a separate opinion, and Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, in a joint opinion, argued that their colleagues should have stopped there and not decided anything more. And I do have a question about that. I think they make a good point on that, and I'm not sure why the other justices went further. And then we will look at that. The court's decision comes just one day before Super Tuesday. Shit, I got it. My ballot's right here. I haven't even looked at it yet. When 16 states and 1 territory will hold their primary elections, Trump currently holds an overwhelming lead in the race for a Republican nomination. Okay, we'll read this here because I think it does help to get an understanding of the breakdown of, okay, we got more here. Trump Minder says the whole Trump saga is kind of hilarious for those of us who don't have TDS, nor love him to the end of the earth. Absolutely right. It's, Dave Smith has said being a libertarian at times is like having a superpower, and I honestly believe that. And even if I've waffled in and out of that whole, once I've taken myself there, I see people like Posobiec and some of these others, Robert Barnes as an example, where you're just like, you're going to lead me down a path that is very bad, right? And I feel like I could just read things in a much better way. So, Valiant Thor. Hilarious how they can criticize Russia for using the law to go after political opponents, but does the exact same thing with a straight face. Absolutely. Very good point. And look, this is once again, this whole, like I said, the superpower of being able to see the hypocrisy. And we all have some of this inherent hypocrisy built into us or confirmation bias. But I think if you can minimize that, or maybe you have to admit, yeah, this is where I'm weak on this issue, and it's just kind of where it's at. The dispute leading to Monday's opinion began last year in a state court in Colorado. A group of voters in that state, just real aiming for democracy, argued that Trump was ineligible to appear on the ballot under Section 3 of the 14th Amendment, which provides, as relevant here, that no one, quote, shall be a senator or representative in Congress or elector of president and vice president. That's the elector. That's the electors from the states, not an elected president or vice president, okay? Or hold any office, civil or military, under the United States or under any state, if that person had previously sworn as a member of Congress or as an officer of the United States to support the Constitution, but then engaged in insurrection or rebellion against the federal government. A state trial court concluded that Trump had engaged in insurrection, but it rejected the voters' request to remove him from the ballot. The court ruled that it is not an, quote, office under the United States, and the president is not a, quote, officer of the United States. That was pretty apparent when you were going through the oral arguments to the Supreme Court that Ketanji Brown Jackson, by the way, I always want to say Jackson Brown just because there's a singer and whatnot, but it's BJ as in blowjob. So it's Brown Jackson. That's how you remember it. Anyway, let's get to the actual opinion, and I'll walk through some of the right, and some of it's kind of stilted. I like to do a little boring, perhaps, but there we go. Okay, so typically it says who wrote this, and that's what I was first confused. I'm like, what? But then it says per curiam, and that's basically unsigned here. And it breaks this down about the breakdown that we just said of how this case got here. Went up to the appeals Supreme Court of Colorado that put a stay on it, and then anyway it goes up there. So their theory, those bringing on the Trump's is not eligible for office. Their theory turns on Section 3 of the 14th Amendment. By the way, 14th Amendment, we've talked about that. You have the Civil War, then you have this rebellion and whatnot. There were people that were from the South that were not allowed to be seated in Congress. Congress goes and passes the Civil Rights Act of 1866. Now, there's going to be problems with that Civil Rights Act of 1866 because there were a lot of the southern states were not represented, and the people were concerned that it was not going to be constitutional. So then they came about and they said, how about we pass this 14th Amendment, which basically mirrors a lot of the same language of the Civil Rights Act of 1866. Boom, you get the 14th Amendment. I've talked about that. I think it's repugnant only because of how now it has been interpreted. And they're going to, let's see, they talk about it here. Not yet. We'll get to it. It's interesting how they preface the 14th Amendment, and people were kind of like, yeah, okay. But anyway, the theory turns on Section 3. Section 3. So Section 5 actually says if you have insurrection, you can't, if you have an insurrection, call a doctor. If it's been more than 3 hours since your insurrection, no person shall be a senator or representative in Congress or an elector of the president or vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. And that is the crux of the ladies of the court. They have a problem with how this, the per curiam, the unsigned opinion of the majority goes about it. According to the respondents, Section 3 applies to the former president because after taking the presidential oath in 2017, he initially incited the breaching of the Capitol on January 6th in order to retain power. They claim that he is therefore not a qualified candidate, and that as a result, the Colorado Secretary of State might not place him on the primary ballot. And then it goes through some of the textual parts of the facts of it. We're not going to go there because that's already taken care of, and I've talked about that, and you should know that. Now, this is what we got. Proposed by Congress in 1866 and ratified by the states in 1868, the 14th Amendment, this is what's so interesting, expanded federal power at the expense of the state autonomy, and thus fundamentally altered the balance of state and federal power struck by the Constitution. That's exactly what it is. That's why I say, fuck the 14th Amendment. Let's get rid of it. But Section 1 of the amendment, for instance, bars the states from depriving any person of life, liberty, or property without due process of law or denying any person the equal protection of laws. And Section 5 confers on Congress the power to enforce these prohibitions along with other provisions of the amendment by appropriate legislation. Okay. That is what's interesting, is Section 5 specifically says these powers are vested in Congress to enforce them, while Section 3 specifically talks about if someone has been found to be an insurrectionist, if they have an insurrection lasting for more than 3 hours, Congress can remove that disability by 2/3 vote. Okay. Now, it doesn't say that Congress is the one that places that stigma on them. That the stigma of being an insurrectionist or has a findings of that. It just says they're the ones that are able to remove this. That's an interesting part. So that's kind of the thing here. They break this down. They say, look, states can remove this disability from holding state office. Okay. You can remove them or not have them disqualified from holding state offices. Everyone agrees with that. And so we don't go much further and saying that. But let me just go here, Section B. This case raises the question of whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to the federal offices, especially the presidency. In our federal system, the national government possesses only limited powers. The states and the people to retain the remainder. Bond v. U.S., that's a 2014 case. Among those retained powers is the power of the state to, quote, order the process of its own governance. Keep going on here. There was one other section I wanted to read here. And by the way, it does say that it has problems with both sides being able to argue fully what and I talked about this before, which is I wasn't fully convinced of the Trump side of their attorneys because they didn't. I'm trying to remember the aspect that I wasn't excited about, but in here there does talk about even them giving concessions. So let's see here. Respondents nonetheless maintain that the states may enforce Section 3 against candidates for federal office, but the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. And this is where Olbermann maybe has his own reading comprehension. I think it's plain, and I think that's the embarrassing part, which is the 9-0 comes out. It's very simple. It's embarrassing that these fuckers even brought this, but here we are. The terms of the 14th of the amendment speak only to enforcement by Congress, which enjoys power to enforce the amendment through legislative pursuant to Section 5. So that's kind of the differences here. Okay, I'm going to skip down to the very end here of it's a 13-page opinion, and they go into a lot of detail about all this here. About states enforcement and their reasoning for it. It's very fine, blah, blah, blah. This is how you argue legally. For reasons, is that the end? No. Let's go to the end, what their last page is here. All 9 members of the court agree with that result. The Supreme Court, therefore, let's go back here, last sentence. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. The judgment of the Colorado Supreme Court, therefore cannot stand. All 9 members of court agree with that result. Our colleagues writing separately further agree with many of the reasons of this opinion provides for reaching it. See Post, Part 1, Opinion Sotomayor, Kagan, and Jackson, J.J. Also, Opinion Barrett J. So far as we can tell, they object only to our taking into account the distinctive way Section 3 works, and the fact that Section 5 vests in Congress the power to enforce it. That's the interesting part here. They're saying, okay, Section 3, there's a disability that comes with, or disqualification that comes with it, and it can be removed in Section 3. But Section 5 of the 14th actually says these powers of enforcement are delegated to Congress. So that's the part that the other section, the ladies have a problem with. These are not only the reasons the state lacks the power to enforce this particular constitutional provision with respect to federal offices, but they are important ones. It is the combination of all these reasons set forth in this opinion, not as some of our colleagues would have it, just as one particular rationale that resolves this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment of the court unanimously reaches the judgment of the Colorado Supreme Court is reversed. The mandate shall issue forthwith. It is so ordered. Now let's just go. I'm going to go through each one of these dissenting, concurring in parts, I guess is what you would call it, not dissenting. Concurring in part and concurring in the judgment. So Coleman Barrett says she concurs, blah, blah, blah. Colorado voters, state law. This suit was brought, yeah, we don't need that. But the majority's choice of a different path leaves the remaining justices with no choice of how to respond. In my judgment, this is not the time to amplify disagreement with stridency. The court has settled the politically charged issue in the volatile season of a presidential election, particularly in this circumstance. Riding on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 unanimity. There it goes. All 9 justices agree on the outcome of this case. So she agrees, Amy Coney Barrett, but she's just like, these bitches are a little too spicy, or maybe the I don't know what she's saying. So that's a little bit much. Okay, this is the concurring in the judgment only, but dissenting on a few issues here. Should we catch up with a few comments here? Let's go back up here. Okay, Ballot Thor, the Dem Party believes that everyone should be free to vote for their candidate and their candidate only. This is the only way to save democracy. Yeah, exactly. Adam Choit, good to see you in here. Okay, Minder, you're going to... hey, finish it out tomorrow. Running on Empty Running on Empty was Jackson Brown. Thank you. Do your conspiracy senses make you think they actually want Trump in power again as controlled op? I don't know or care necessarily. I'm just reading the legal shit. I'm not you want to go to Nephilim Death Squad if you want the conspiracy stuff. I actually believe these people on the court are trying to do their job. Okay. And they're somewhat predicated by their politics, which got him put in position in the first place. But this was a tough one to go outside of the norm. I mean, it was pretty obvious. It was so obvious that when this first came about, I was like, wait, what? This is all about the Civil War. I mean, I didn't even really know about this provision in here, honestly, because the 14th Amendment is always about incorporation, equal protection, due process. We talk about the 14th Amendment all the time in law school, but it's as issues applied to the states for due process. So it just doesn't even come into this. So anyway, Magoo, hey, what's up? What's up, Magoo? All right. It is not necessary to decide more to dispose of a case than it is necessary not to decide more. In Dobbs v. Jackson, just recently done, that fundamental principle of judicial restraint is practically as old as our republic. They write, this court is authorized to, quote, to say what the law is, only because those who apply a rule to particular cases must of necessity expound and interpret that rule. Marbury v. Madison. Today, the court departs from that vital principle, deciding not just this case, but challenges that might arise in the future. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot, blah, blah, blah. Allowing Colorado to do so would, we agree, create a chaotic state-by-state patchwork at odds with our nation's federalism principles. So they did talk about that, which is you can't do this. You can't go each state making these different determinations. It's completely true, and I'm glad they did this. The Democrats should be glad too, although, you know, the reality would be, this is how you'd argue, which is like, you better watch out. You never know what's coming for you. But then they're like, yeah, well, it's Republicans. They're not going to do anything about it. That is enough to resolve this case. Yet the majority goes further, even though all 9 members of the court agree that this independent and sufficient rationale resolves the case. 5 justices go on. They decide novel constitutional questions to insulate the court and petitioner from future controversy. So that's the interesting part. And so you're asking yourself, so here's the dichotomy here, right? The how you do this. The Supreme Court's come in and said, 14th Amendment does not allow the states to disqualify someone for the presidency. So get fucked. Okay, fine. But then the 5 concurring justices go, okay, Section 5 is the only way to do this. Therefore, it's got to be legislative intent. It's part of this by Congress to actually enforce this, because they did talk about a history, and there's an enforcement act and some history of people holding offices, and they're like, after the Civil War, and they're like, hey, what's going on here? Well, Congress is coming and they can do this. Now remember, if there's a disqualification that's already upon them, 2/3 vote to remove that. So if that were to be the case, but what the Supreme Court justices are saying here is, okay, but the Congress is also the only ones that can do that. So if you want to remove Trump from the ballot, you've got to have it basically an act of Congress to do so. These justices are saying, well, wait, I don't know. And so my question, they're saying, you're saying now you're funneling it all in, saying it's the only way to do it. We don't agree that that's the case. We don't think that that's the way the Supreme Court has ruled. Matter of fact, you shouldn't have even said anything about how that, just leave that open. Okay, so what are the other ways? What are the other ways to disqualify someone from the ballot? And I think there are federal laws that you can be tried, and I think that's what they're leaving open, which is criminal prosecution for insurrection, at which point you would be found to have, there'd be a findings against you of insurrection, at which point you would be disqualified. Then Congress would have to come in there and remove this disability from, your ability by 2/3 vote. But the Congress, the Supreme Court has actually come out in the majority and said, you know what? We're also just going to say the Congress has to be the one that actually disqualifies them too. I think that, at least that's my reading on it. And so I understand where they're coming out from this, and I don't know how I feel about it, because I think it kind of just, it then kind of takes away some of this bite. If you have, someone that's an outright insurrectionist, they have an insurrection lasting longer than 3 hours. Let's see here. They talk about the majority rests on the principles. Nope, that's not what I wanted. Here we go. Yet the court continues on to resolve questions not before us. In a case involving no federal action whatsoever, the court opines on how federal enforcement of Section 3 must proceed. Congress, the majority says, must enact legislation under Section 5 prescribing the procedures to ascertain what particular individuals should be disqualified. These musings are as inadequately supported as they are gratuitous. To start, nothing in Section 3's text supports the majority's view on how federal disqualification efforts must operate. Section 3 states simply that no person shall hold certain positions in the offices they are oath-breaking insurrectionists. Nothing in that unequivocal bar suggests that implementing legislation enacted under Section 5 is critical. What would mean in this context? In fact, the text cuts the opposite way. It does, actually. Section 3 provides that when an oathbreaker insurrection is disqualified, Congress may, by a vote of 2/3 of each house, remove such disability. It is hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation. by repealing or declining to pass implementation legislation. Even petitioner's lawyer acknowledges the tension in Section 3 that the majority view creates. There you go. I think that's pretty much what we had to see if they had any other parts that I want to talk about. What it does today, the court should have left undone. That's what they finished it on. There you go. All right. So my face is a little flush. My eyes are a little red because I've been out riding my bike today. And I got dirt in it this last the weekend from riding. It's been problematic. Let's go to Twitter and see if there's anything being said about SCOTUS. That's where I found that guy's I got to find that guy that, okay. So maybe we'll just cruise through here because some people, it's always interesting to see sides of this. Oh, the SCOTUS is amazing. 9 Americans are the last bulwark against treachery of the left. This is James Wood. Okay. Oh, look at that. That's us. SCOTUS. What else we got here? I want to see if any of these people have anything to say.
Delay it. And so, Jason, I turn to you. Our lonely nation turns to you, not because you've practiced law as long as David Kelly or prosecuted as many tough cases as David Kelly or run the Southern District of New York like David Kelly, who, as I remind people, was my former boss. But, Jason, because I wonder whether the Supreme Court is acting in a way that will ultimately be deemed by the evidence to look more partisan than legal. And what are your political thoughts on that?
It's absolute partisan. This is garbage. And honestly, Ari, I think the public at large and Democrats in the White House and, frankly, Elena Kagan and Ketanji Brown Jackson and Sonia Sotomayor should be standing up and screaming right now. This is an absolute disgusting abuse of power. And let me make this clear for the non-lawyers out there, because I'm the non-lawyer who's here. I'm explaining this. I'm on campus right now. I was explaining this case to my students today. And they're literally saying, well, why is this taking so long? This isn't that complicated. I literally had to show them a video from Lethal Weapon 2 about diplomatic immunity to explain how silly presidential immunity is. This is not complicated. It is very clear that we have an absolutely corrupted Supreme Court, that at least 3 of the justices have financial dealings that we can't explain. Gorsuch, Kavanaugh, and Clarence Thomas. And rather than the court demonstrating that the only audience that matters is the American people, they have shown that the only audience that matters is Republicans. That is the problem with this. It's not complicated. It doesn't require a lot of legalese. They are stalling in order to allow Donald Trump to get into the White House, or at least have a chance to get into the White House. And given the fact that a third of the court was put into office and put into their positions by him, it's not that hard to tell. So, Ari, the concern that I have, frankly, is not what's going to happen legally, but the fact that we have a government that has taken so much time to hold this man accountable that he may never see the jail. This is as real as it gets. He may never see jail. And it's going to be because we can't trust our Supreme Court, and Merrick Garland didn't do his job.
So that's on the politics. Then, David, my control room and my producers and I, we were talking.
Okay, so I think this, I'm just reading up in here. So that clip is about the Supreme Court taking up the immunity issue that we just talked about with Robert Barnes. They're saying they're not going to do it until after the election. So I can see why the left is upset about that, because the reality then is he takes office, he gets, let's say he's elected, now he just has immunity. Now he has immunity he can give himself immunity or a presidential pardon, I guess. Maybe that's the question. Can you give yourself a presidential pardon? But those are only for federal issues. So the state issues are still there. What are you going to put him in prison as he's the president? This is what's interesting. This guy, these people are so insane on their TDS. It's hilarious to me. And by the way, our Ketanji Brown Jackson, BJ, there you go. Brown Jackson and Kagan, are they traitors? I don't know. What's going on? Do I wear suspenders in court? I do not. By the way, you said Dennis had a field day as Keith. Did I read did I read Keith Olbermann, or did I read actually? No, that's that. It's funny that Dennis's isn't much different than the actual Keith Jackson's. Keith Jackson. Jesus. All right. So people, I hope that's 40 minutes there. I hope you have an understanding. I have an understanding of the Supreme Court ruling, and we just gave it to you. I think it's pretty plain and simple. What is it, the takeaway? States don't have this ability to do, though. What's the big breakdown of the Supreme Court? Supreme Court says the states can't do this, and we're leaving it open. He's on the ballot. Fuck you. The chick up in New Hampshire, I think it was what it was, or somewhere up there in the New England states. Illinois just did it. Colorado is doing it. They're all screwed, and they're all just showing themselves about what insanity that they have. It takes me back to the good old days. Clinton's in office. He's popular. He's winning with everybody. And me as a right winger, I'm like, but he's getting a Blue Jay in the off. And it's like, okay, so if you remove him, what does that do? I mean, this is the problem. It really does. Why don't you got to win in the the world of ideas or power, and going after your opponents politically just because they're shit. Yeah, okay, whatever. So it's kind of the same thing, and the left is going to lose on this, I think, as well. So anyway, there we go. That's my breakdown. So once again, states can't remove someone from the ballot. Okay, Supreme Court then says, hey, the Congress is the only one that can actually do that. And the part of those and we'll see if this comes about, if there's an issue there, if it comes down to where we'll look back later and go like, oh, those bitches, they actually had a good point. Maybe we should have gone there. I sent a message to Binkley for, oh, thank you, JC. Timcast fell for what? What did he fall for? Oh, for Dennis. By the way, when I see something out there that's outrageous from a lefty or whatever, I click it and I look for the pounded twinks or whatnot. And usually I find it there. So stop. Okay, Pixies are coming in. So we're gonna end it there. Yeah, thanks for that. Or maybe we'll try to get Brad Binkley on. We'll do a little Fannie Willis. Wednesday, Tower Gang, my Talking Towers. I have it all ready to go. I'm doing something a little bit different this time. So hopefully those fuckers will stick around for it. Next Friday, I still should be doing a show. So I don't know what we're going to do. Maybe we'll do a little bit. And if you guys have anybody out there that you're like, hey, Tyler would be a good legal guest on their show, send him a message. Hit me up. Make it look good. See you guys.
Okay, I'm leaving now. Bye, guys.
But she's back.
And now.
Chick-fil-A is completely overrated. It's not that good. I prefer Zaxby's. I prefer Popeyes.
Takes a tough man to make a tender forecast, Nick. I guess that's me. Keep fucking that chicken.
Should I vote for Dick Cheney on the Libertarian Party? Do I have an obligation to vote for Dick Cheney?
I would say so.
Yes.
Did it work for those people?
No, it never does. I mean, these people somehow delude themselves into thinking it might, but it might work for us.
That one dude was like, not a podcast. I can't find it anywhere, and they don't have video.
Oh, yeah, Peter Janke. Yeah.
Yeah, I blocked him.
I'll do it. If he unblocks me, I'll...
He'll buy your shirt if you unblock him, Bert.
He's a wigger.
Yeah, nothing cooler than a 49-year-old wigger. I just started live streaming. Cut me some slack. I'm pretty high tech for a boomer. But anyways,
boomer.